Well, in APHE batch matters a lot. We have submitted our. Just okay.
Item 20, review petition 31/2020.
Review petition is dismissed.
Item 21 with 22, readable 350/2022, 142/2023.
The appeal against the judgment and order dated 28/7/2022 passed by the learned single judge in WBC 7342/2017, being date appeal 350 and 142/2023 are partly dismissed by holding that the impugned judgment, holding that the appellant in writ appeal 350/2022 did not have the minimum qualification for his selection and appointment to the post of assistant executive engineer is non-honest and invalid in law and warrants no interference whatsoever. However, both the appeals are partly allowed insofar as the one part of the judgment, an order dated 28/7/2020 is concerned, whereby direction was issued by the learned single judge to that the writ petitioner, namely Dipankar Das, is required to be construed to be the second candidate as per order of merit and provide for the consequential order and benefit, with further directing that the reasoned order be passed within a period of 4 months. Under these circumstances, the writ petitioner is found entitled to a cost of rupees 30,000 to be paid by the appellant in writ appeal 142/2023, that is IIT Guwahati. The cost shall be paid within outer period of 45 days from the date of receipt of bank account particulars by the of Dipankar Das, failing which the same shall become recoverable in accordance with law. Corrections.
May I please your lordship, praying for listing and read petition, the petitioner's father is detained by the border police without informing the government. They are detained more than
Friday.
20.
Give it.
Obvious.
This, in pending writ petition, my lord, he was on bail all along attending, but he has been arrested and so far the information is, my lord, there is an attempt to deport, my lord, within a short period, my lord. May I pray for listing matter tomorrow, my
You will
lord?
have to file an IA.
I,
If you have to pass an interim order, there must be a prayer.
my lord,
File an IA. Will permit it.
Friday.
No, whenever you want, you pray it and then make a
We have
mention.
filed it, my lord.
Huh?
We have filed IA.
You file an IA. Make it Friday.
Or if possible, my lord, tomorrow, my lord.
Tomorrow, no. We have
Well.
certain parted matters. We have to complete
Friday, my lord.
those one.
Lordship,
Lordship.
Oh.
Lordships, expertise matter, Lordships. It was last listed on 26/3/2025. And
After vacation,
on bail
after vacation,
after that,
you're not taking up any matters.
27.
If you file an IA, we can take it up, but not otherwise.
well, the APSC batch writ appeals.
Yes.
Our submission we have submitted.
Yes, we have got it.
Lordship.
We have got it.
All right.
Can I have a copy, my lord? A copy of the
Pardon me?
written submission today submitted, a copy of the written submission will be allowed to be given to us.
Just tell him, he'll give it to you.
Lordship, in item number 10, we have filed one affidavit today, Lordship, that may be called for us.
May I please, your Lordship. Lordship, in WPC number 6083/2025, the Lordship has granted bail to the petitioner on 11/6/2025 with a direction to appear within 10 days before the SP border Bozali. He has appeared before the SP border Bozali. Now the SP border Bozali is refusing to accept the order, Lordship.
Okay,
Lordship, tomorrow or day after tomorrow, Lordship.
day after tomorrow.
Lordship. Obliged, Lordship.
May I please your lordship, I beg-
Mr. Sharma, just take the number from him. The SP border is not accepting the bail.
why it was not accepted, lordship?
Just find it out. Listing it to day after tomorrow. You give the case number to him also.
Lordship.
I'm mentioning for listing one matter, my lord, in admission column in any date in H2, my lord.
New matter or old matter?
Admission matter, my lord.
Admission is after this, after a few days, not now.
There is no bail, my lord, police is
We
searching.
can't help it.
Obviously, my lord.
Unless we complete that hearing matter, we just can't divert our attention.
Item 1 for motion.
May it please the lord.
Impugn doesn't is page
Page?
67.
2019 matter.
Yes, Lordship, your Lordship put the question of delay. Will satisfy your Lordship. The matter of delay, Lordship. I brought a question judgment of honorable Supreme Court. Judge.
Okay, we issue notice, keeping the maintainability open.
Yes,
Bail will be considered on receipt of records.
Lord.
Heard. Mr. R. Sharma and counsel the petitioner. The respondents are there. Mr. Islam on behalf of Nadia Ali. Page 67 is the opinion dated 24/9/2019, passed by so in case number FT so and so, IMDT reference number so and so. holding the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable on 23/7/2021. Extra copies within 2 days. That the relevant records be acquisitioned from the learned tribunal. So as to reach this vote by the next date of listing. Next para. In prayer for bail shall be considered on receipt of records. List on so and so.
Maintainability. Not maintainability.
Huh?
Maintainability.
Just before that issue notice, just say keeping issue of maintainability open on ground of delay and latches.
Well,
Item 2.
I'll give.
I place a question. In order, your lordship, page 82.
Twenty-five, 10/2024, passed by so and so. Case number so and so, reference case number so and so. Holding the petitioner to be a foreigner of post 25/1971 stream. Notice return within 4 weeks, call for the extra copies in 2 days, call for the records. Prayer for bail is opposed by the London Standing Council for the FT matters, considering the projection made in the petition. 10 days time to take bail of rupees 5,000 to the satisfaction of
SP border Dhubri.
SP border
Dhubri.
Dhubri. Okay.
Obligation.
Item 3.
If we will not say. Lordship, we had earlier approached this honorable court by filing a writ petition number WPC 6180/2023, Lordship. Lordship, interim was granted to us by order dated 18/10/2023. Lordship,
Where is that?
Lordship, page 54, Annexure L.
54, yes.
Relevant part is at page 57.
Yes.
Lordship, after that, the petitioner it came to the notice of the petitioner that there were some typographical error in the cause list of the writ petition, Lordship. The Lordship, the petitioner had filed an IA, this IAC number 3691 of 2023, Lordship. Lordship, the IA was fixed on 19/5/2025. When it came to the notice of this honorable court, the Lordship, along with the error in the cause list, there was also some error in the affidavit of the writ petition, Lordship. So this honorable court directed us to file a fresh writ petition. Liberty was given to us, Lordship, and the interim was vacated. The order is annexed as Annexure M, page 58, Lordship.
Okay. Mr. Sharma, we give a bail. But Miss B. Goi,
A.N. Hussain.
Miss
A.N. Hussain.
A.M. Hussain. Learned counsel of the petitioner. Opinion is at page.
Lordship 33.
Hmm?
33 lots.
33. Following this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 7/11/2020, passed by so and so in case number so and so, BNG and IMDT reference number so and so, holding him to be a partner post 25/3/1971 stream. Next paragraph. By referring to annexure L to the writ petition, it is submitted that this court, while issuing say that on an earlier occasion, the petitioner approached this court to challenge the impugn opinion dated 7/11/2020 by filing WPC 6180 of 2023, and this court by order dated 18/10/2023, while issuing notice, granted bail to the petitioner on certain conditions. Stop. It is submitted that when the matter was listed on 19/5/2025,
Go ahead.
while taking up IA Civil 3691 of 2023, which was filed for amendment of the cause title, the court noticed mistake in the particulars against the name of the petitioner as shown in the affidavit filed in support of the writ petition. Accordingly, with liberty to approach again, the said writ petition was dismissed and withdrawn. With a further direction to the registry to maintain the records for 30 days. Next paragraph. If you notice returnable in 4 weeks, because extra copies of the writ petition will served on the CG State and Department Council within 2 days. Next paragraph. At the records of WPC 6180 of 2023, which was disposed of by order dated 19/5/2025, be tagged along with the record as the records of the tribunal is available therein. Next para. Prayer for bail is proposed by the London Standing Council for the FT matters. Next para. Having noticed that the petition was previously granted bail by order dated 18/10/2023, passed in WBC 6180 of 2023. The court is inclined to grant bail, 10 days time to take bail of rupees 5,000 to the satisfaction of
Border Bongaigaon.
Bongaigaon.
SP Border Bongaigaon. Okay.
Item 4.
Baker Archer, my lord. My lord, the page 11, Annex 1, that's the opinion and order. I'm just reading out the operative portion for lordship's kind convenience.
Which page is the,
Page 15, para 20.
no, which page is that opinion?
Opinion is at page 15, Annexure 1, my lord, page 20. Para 20, my lord, Annexure 1. Para 20.
So opinion of 2023. You have to
No.
wait for some time for bail. We are not granting bail. You write this one.
My lord, the question is, my lord, my father is an Indian national.
Whatever will be the very good reason, but you are delayed. You are approaching after 2 years. You're not granting bail. You know how to protect yourself.
My lord.
Heard Mr. SSS Rahman and counsel for the
My lord, I
petitioner.
am SSA Rahman.
SSA, I'm sorry. SSA Rahman and counsel for the
Zimbabwe is
petitioner.
triple S.
It's okay. I have made a mistake. The counsel for the petitioner. All the respondents are there. This opinion is at page 11, dated 24/5/2023, passed by so and so and so and so. Thereby holding the petitioner to be a foreigner of post 25/3/1971 stream. Notice returnable on 23/7/2025. Extra copies within 2 days. Call for the records.
5, 6, 7.
Prayer for bail shall be considered on receipt of records. List on 23/7/2025.
My lord, obliged me.
Item 5.
May please lordship. My lord, opinion is at, my date is, my lord, 18/12/2023, my lord. Delayed of 2 years, my lord.
Same order.
Same order, my lord.
But Mr. SSS Rahman and counsel.
I'm triple S, my lord.
Your, the opinion is that page. Opinion at page.
My lord, at page, my lord. 11, my lord. Operative person is at page, my lord. 16, my lord.
Okay. Page 11. Opinion dated 18/12/2023. Passed by so and so and so. Same order.
23/7.
23/7/2025. Same.
Obliged.
Yes, item 6.
Maybe locked.
Yes, Mr. Abhi.
Full order page 51, madam.
51.
Yes, madam. Delivery per month 50.
There is some delay. What is the earlier opinion?
My lord, 12/1/2024, my lord.
No, no, there is an earlier opinion. What is that?
My lord, this is the first opinion. Madam. This is the first time. Madam.
No, no. Acha, okay. Okay,
first time. Earlier.
okay. I mixed up something. But Mr. H. Halil, I'm a counsel for the petitioner. Opinion is at page 51, dated 22/1/2024. Passed by so and so in case number so and so. Reference case number so and so. Holding the petitioner to be a foreigner post 25/3/1971 stream. Notice extra copies within 2 days. Let the records of the tribunal be requisitioned from the concerned tribunal. This is Tejpur.
Yes, yes.
First of, apart from regular requisition, the requisition shall also be sent by email to the following email address of the concerned tribunal. Next, the prayer for bail shall be considered on receipt of records. List on Swenson. Pardon me?
2014 my lord, 2014, 2024 my lord, 2024 my lord.
January 24 lordship sometime.
It's 24, that's
Yes, my
why
lord.
some delay.
My no delay, my lord, actually my lord, I kindly see my lord, my.
Okay, you just say that in the event the petitioner is apprehended, he shall not be deported out of the country without order of the court.
Item number 8 is wife, my lord.
Item 8 is wife.
Yes, my lord.
Same date opinion.
Opinion date, my lord, same court, my lord, but all, but some different date, my lord, 2/4/2024.
Item 8.
After 2 months. Tribunal is same, my lord. Is 49, my lord.
Mr. Charlie, then counsel for the petitioner. Opinion page 49, dated 2/4/2024. They were holding the petitioner to be a foreigner post 25 to 1971 stream. Same order. Not to be deported without order.
Hello.
2008. 9.
Item 7.
May I please as your lordship? My lord, the
Yes.
may I please as your lordship? My lord, the opinion is of 27/2/2025 is at page 97, my lord. It's a very long and elaborate opinion has been, my lord, exercised by the
You want us
Honorable-
to dismiss it now?
my lord,
Once
lord.
it is detailed and elaborate,
my lord.
then you know the principles of certiorari.
But my lord, when the detail and elaborate is done, but there is the discrepancies is apparent, my lord.
Okay.
My lord,
Sir, A.R. Bunyad and counsel for the petitioner. All respondents are there. Opinion at page 97,
Yes.
dated 27/2/2025, passed by so-and-so in FT case number so-and-so. IMDT case is in para 1, huh? I'm underlining it. IMDT case number so-and-so. Holding the petitioner to be a foreigner post 25 to 1971 stream. Notice extra copies within, notice is returnable in 4 weeks, extra copies within 2 days. Call for the relevant records from the concerned tribunal. The prayer for bail is opposed by the learned standing counsel for the active matters. Considering the projection made in this petition. 10 days time to take bail or ₹5,000 to the satisfaction of
SP, my lord, SP Bozali, my lord, district.
SP Border Bozali.
My lord. Okay. Oblige, highly oblige.
Item 9.
Lordship, the petitioner was declared an ex parte foreigner by order dated 22/10/2008 by Foreigner
Page-
Tribunal Jorhat, Your Lordship.
Page,
Page 24 is the opinion, Your Lordship. Annexure 2.
The correct only. Incomplete will decide. Before I did it. 2008, 22/10, Joratot asile, hui ahile, without informing the police. কিন্তু যোৰহাটত যেতিয়া আহিছে ক'ব লাগিছিলে পুলিচে এই ইনকুৱাৰী ৰিপৰ্টত চব লিখিছে বয়স কিমান
heard. Mr. Z. Khalid and counsel for the petitioner. All the respondents are there. Filing this writ petition under Article 226 of the Constitution of India, petitioner has assailed the party opinion page 24, dated 22/10/2008. passed by the learned member, Jorhat, Foreign Tribunal Jorhat in GFT case, GFT, in case number GFT 819 of 06. Next, by keeping the issue of maintenance be open, maintenance be open on ground of delay and latches. Written notice returnable on 23/7/2025 be issued. Extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Full stop. Apart from. It's okay. The prayer for bail shall be considered on receipt of records. List on 23/7/2025.
Supplementary item 23 for motion.
Kindly see the last order.
Okay.
বিভিন্ন আছে ৰেকৰ্ড এবাৰ চালা নেকি কিবা আছিলে
Yes, please. Okay.
পাছৱৰ্ডে কি আছিলে আমাক কি আছিলে
Yes, Mrs. Verma.
We have gone through the record from Sarkar. Hmm? Lordship, this was a ex parte opinion. Lordship opinion is at page 16.
Yes.
And opinion dated is 2022. Lordship will come to page 18, Lordship. That despite paragraph 3, page 17, last paragraph, Lordship. After receipt of notice, she appeared with her engaged counsel for further time.
Page 18.
Page 17, Lordship, first
17.
at
Ah,
17. After registration of the case, notice was issued and the OP Hashmat Ali appeared, Lordship, along with his counsel and great time to file his WS. But in spite of caution, he did not file his WS on several occasions and kept on taking time again and again, Lordship. Then paragraph 3, that despite last opportunity was given to OP to file his WS, but OP paid no respect to the liberty of the order of the tribunal. The order dated 23/8/2022 is quoted below. That despite last chance was granted on 12/8/2022 to OP to file her WS, but OP is negligent and misused the liberty and grace shown by the tribunal and remained absent without any step. A learned advocate is also absent on behalf of OP. On 12/8/2022, this tribunal made clear that in the circumstances, if the OP failed to submit her WS, no adjournment in a routine manner will be granted and the case will proceed as per FT Order 1964. The OP on receipt of the notice appeared in person with his engaged counsel before this tribunal on 18/4/2022, and since his appearances, 8 adjournments were accommodated. The dates are their lordship to file her WS beyond the mandatory period of 10 days as per 358 of the FT order 1964. In the interest of natural justice, to defend a case as citizenship is a valuable right. The learned AGP moved a petition on 23/8/2022 and have vehemently objected against the conduct of the OP, and have also submitted that despite opportunity was granted, the OP failed to submit his WS, and also submitted that it can be reasonably inferred that OP has no document to substantiate his citizenship claim, and as such, OP is taking time again and again to delay the proceeding. Perused the petition and the learned AG, and also heard the AGP objection at length. So since lordship, despite of getting sufficient opportunities, the petitioner failed to file the WS and have again and again sought adjournments for about 6 months, more than 6 months, lordship. The tribunal, finding no other way out, lordship, went ahead and passed the final order, that is on 17/9/2022. And the reasonable before the court. So, despite the opinion being passed, lordship, petitioner has approached this court only after 3 years, and nothing special has been mentioned about the delay or why it should be entertained, and why this petition should not be dismissed, lordship. An ex parte judgment, lordship, there are a whole lot of judgments proceedings said that the petitioner is given a chance. They have accepted the notice. They have appeared before the tribunal, but they have failed to file their WS along with the supporting documents, lordship. And then one find is just stop appearing, and the tribunal has to proceed with the opinion proceeding to bring it to its logical conclusion, lordship. So, lordship, for delay and latches, I would like to rely on Mrinmay Marty, lordship, and then sufficient opportunities granted. The petition has been sitting all along. He has not exercised his right. He has been negligent in his proceedings, lordship. I got no diary trust. So if we can. And it is not that the petitioner was not aware of his proceeding, lordship. The reference inquiry is of 98, lordship. Case registered in 17. Proceedings started. And from 17 to 22, nothing, he couldn't make out a case, lordship, could not collect the documents to prove his citizenship. So, lordship, the
Just
first.
on the record for a moment. Please pass the record for a moment.
No, just a submission. Just a submission. কোৱানে যদি তুমি জনাই দিয়া। স্পেচিয়েল গ্ৰাউণ্ড দেখুৱাই দিয়া না। Citation আছে। Can be recalled only in special circumstances. Special circumstance not exact.
Referring to which decision this was?
Yes, Lordship. First would be Lordship. Sufficient opportunities granted continuous default thereafter, and only after giving adequate opportunity the ex parte order was passed. This is WPC 1293 of 2023
1 to 9
2021
of
of 2020 Lordship, decided on 5/1/2021, Sarijan Nesa,
how do you spell it?
Sarijan,
S S.
Sarijan, Nesa, NESSA versus Union of India. Then Lordship will come to WPC 8361 of 2019, decided on 12/10/2020, Ijjat Ali versus Union of India, IJJAT Ali. This is in the proposition of endless proceedings. Then Lordship, there's one more, WPC 82 of 2024, Baten Paramanik. To decide.
Please give it again.
Baten, BATEN, decided a case again. Paramanik, PARAMANIK.
Decided on.
Lordship, I'll give the date, Lordship. Just missing it out. It's
Petition number also.
WPC 82 of 2024.
82.
82.
Okay.
Lordship, the next one would be WPC number 291 of 2024, decided on 23/2/2024, Baharul Islam, BAHARUL Islam versus Union of India. Lordship, two more I would like to tell. One is the writ of certiorari, Lordship, that is Central Council of Research in Ayurvedic Sciences 2023, SCC Online, SC 996, paragraphs 54 onwards. Then Lordship, one more which I would like to rely on is a ex parte order dismissed. A review was filed, Lordship, and Justice Bhuiyan had passed this order. Proceedee has not only slept over the matter after receiving the notice, but had not even cared to appear and file the WS, which clearly shows gross negligence on their part. On the fundamental principle, it is submitted that law helps those who are vigilant about their rights. This is review petition 55 of 2020. Ananda Das versus Union of India, decided on 1/2/2021. Mehti to delay and latches. Lordship, on delay and latches, we would like to rely on
Yes.
2024 live law SC 318.
Live law we won't have.
Lordship will give a copy. It will. My friend will write it and give it, Lordship. SC 318 Mrinmoy Maiti, MRINMOY. Maiti, MAITY versus CHHANDA, KOLEY and others.
Minimum mighty versus
Versus Chanda Kole, CHHANDA, KOLEY and others. Paragraph 7 onwards, Lordship.
okay.
Lordship, I have the civil appeal number. Can I give that, Lordship? Civil appeal numbers.
You give a copy, we'll see and
Yes,
then
we'll
we'll
do
send
that,
back.
Lordship. Then, Lordship, there are Karnataka Power Corporation and Chennai Metropolitan Water Supply. These are all on delay and latches. Mrinmoy Maiti covers one of them, Lordship.
Yes.
Yeah, para 7 onwards. That was the vote. I will ask them.
Yes.
On the last occasions, Lordship, I have admitted there is some deficiency. Definitely there is deficiency on the part of the petitioner, Lordship. Lordship, what happened, Lordship? The name of the petitioner's father were recorded, Lordship, in the voter list of 1955. And when the petitioner applied for certified copy of the Lordship, the voter list of his father, Lordship, that voter list is not available in the election office.
Okay.
Readings of 9. These are not part of.
From where do we get that?
Lordship,
From where do we understand that it is not available?
thereafter, Lordship, we collected the voter list from Panchayat office, Lordship. You have mentioned.
These are
Thereafter-
part of the pleadings, Lordship.
Just a moment,
Yes,
let him
Lord,
complete.
it is on
Let,
pleading,
uh,
Lordship.
Yes, Mr. Sarkar.
Yes.
From where do we understand that the voter list is not available?
Lordship, we have searched in the election office, Lordship. And due to Lordship erosion of river, Lordship, that area is Lordship left out in subsequent voter list also, Lordship. So Lordship, 1955 voter list only remains voter list of his father, Lordship. And that voter list is not available in the office. And so far the linkage is concerned, Lordship, we have annexed the Jamabandi copy. Another ground of my Lordship, we have challenged this order basically on the ground of LVS report, Lordship.
In LPS report, Lordship, the date of the petitioner was shown as 1/1/1961 and place of birth was shown as Kolabanda, Lordship, in Barpeta district, Lordship. So, Lordship, the LPS report itself proves my citizen. In this regard, I brought in citations also, Lordship, in which is clarified, Lordship. Lordship, page 21 of the records may be seen. Page 21 of the records, Lordship. And page 21 of the records. Serial number 4 in LPS report. Date of birth 1/1/1961 and serial number 5, place of birth, Kulabanda. And that part is, Lordship, in LPS, in regarding the LPS report, Learned Tribunal observed that, Lordship, that is in page 21, para 11, Lordship. That may be seen, Lordship. Page 21. Learned Tribunal, Lordship, discussed the portions which is against me, Lordship. And so far the serial number 4 and 5, Lordship, wherein my date of birth and place of birth mentioned, that is not properly discussed. Lordship. There are 11. May I read, Lordship?
Yes.
Peruse the case record along with the report of the local verification officer and electoral registration officer. It is a long pending case, pending since 1997, when the LBO made an inquiry during intensive revision of the draft roll in pursuant to the order of the Election Commission of India on the basis of door-to-door enumeration. Case record reveals that local verification officer during spot verification visit inquired the citizenship status of OP. After spot verification, the LBO filled up the form in Annexure 1 format and noted at column number 8. He skipped, Lordship, column number 4 and 5. That his father registered as an elector. In column number 9, the LBO noted that at part number 70, serial number 804 of 1993 under 47 Shanghai LAC, his father name is enrolled. The LBO also noted that serial number 804 of 19 is of cancel list. This much information LBO could collect during spot verification and could not fill up the other column. This much information LBO could gather during the spot verification inquiry of OP. Lordship, so far the serial number 4 and 5, that is not discussed. In paragraph 11, he discussed column number 9. If the Lordship, the serial number 4 and 5, wherein Lordship date of birth and place of birth were taken into consideration, Lordship, then it is clearly reflected that my place of I am an Indian citizen I am citizen of India. In this regard, Lordship, in a similar cases, Lordship, I have brought in citations, Lordship. Lordship, I am going to relevant portion, Lordship, para 8 may be seen, Lordship, for a moment. Para 8. A reading of the signed format for verification of officer's report under the signature of local verification officer dated 16/2/2005. Although the name and designation of the verification is not clearly readable, makes it discernible that format was filled up to clause 7, which shows the name of the petitioner, her address, her husband's name, date of birth, and place of birth. The date of birth is shown to be 16/12/1969 and the place of birth to be the Nalbari. If the information had already been collected that the petitioner was born in 16/12/1969 and her place of birth is Nalbari, we see no reason as to how the petitioner can be suspected to be person who may have entered the state of Assam from the specific territory subsequent to 25/3/1971. But what is more intriguing is that clauses 8 to 14 of the format had neither been filled up nor the information required therein had been inquired by the local verification officer, and the entire clauses have been struck out as if such information are not required to be gone into. As an answer to the to query at clause 15, whether the petitioner had migrated into Assam, the answer given is yes, but without providing for any reason, and the opinion formed by the verification officer was that the petitioner had migrated after 25/3/1971. And subsequently, Lordship finally the opinion was set aside, Lordship, on the basis of that information, Lordship. So I am similarly putting my place of birth mentioned Kulabanda, Dhubri, Borpata district, and my date of birth 1/1/1961, Lordship. So there is some dereliction on my part. This is admitted position, Lordship. I have not disputed, Lordship. A chance may be given, Lordship, to contest the case on merit.
Okay. Examine and pass orders in chambers.
Lordship, just a small submission, Lordship. The voters list of 1955 is not a certified copy, Lordship.
We have mentioned in our paragraph also.
Yeah, it is not a certified
Yes.
copy, hence it cannot be taken as a piece of evidence, Lordship. And 66, he's saying in, got washed away by erosion, Lordship, that nothing to prove that, Lordship, just a statement. And after that, from 55 to 66, and then to 2005, nothing in between all these years, Lordship.
Item 24.
And 24 and 25 are tagged together. The Lordship takes up 25. A learned friend was to appraise this court regarding the opinion passed in my brother's matter, which I have annexed in the additional affidavit. Whether my case can be referred back to the stage of evidence.
Which page is your brother's opinion?
Page 35 of the additional affidavit. Annexure 8. Mohammad Fakruddin and Mohammad Jilaluddin are both my brothers.
Lordship, issue of maintainability and delays also there, Lordship. That needs to be addressed first.
You are referring to page 35.
Page 35 is the opinion of my brothers of the additional affidavit, page 35. In item 25.
Item
25. Jalaluddin.
25.
You need to size it down, need to side here now. It will miss one, right? It to 28.
In the second paragraph of the opinion, at page 36, sixth line, opposite parties have two other brothers, namely Jalaluddin and Abdul Ali. Jalaluddin is the current petitioner. And my brothers
Just a moment. Where is your written statement?
And that is not annexed. That is not annexed. And my opinion is at page 19. And this is by the same tribunal and same member. Reference হৈছিলে আৰু ওঠৰ হৈছিল তেওঁলোকৰ বহুত তেওঁলোকৰ এতিয়া দিলে 25ত ক'ব লাগিছিলে এতিয়া এটা
Your opinion is at page
19, 19.
19.
That my father was Kudrat Ali and also known as Basha Sheikh. That was not considered. Whereas in my brother's opinion, that was taken into account. From that place to
Mr. Sharma, please send the records.
Lordship record is not yet received, Lordship. This is a motion statement. No, earlier occasion, I think Lordship has only directed the petitioner to explain delay why. He was come late, Lordship, before this honorable court. That also I have explained in the additional affidavit. Because order is of 2018, Lordship. I think Lordship, it was not properly explained, Lordship.
We'll call for both the records, but we are unable to grant you bail.
Only one record. I mean, regarding the petitioners in 24 and 25, there will be only one record, because only one reference.
Okay. Since you are projecting that you are, your brother has been declared to be an Indian, we'll say that you will not be deported out of the country without order of the court.
Declared as streamed foreigner.
Hmm?
Streamed foreigner. Foreigner between 66 to 70.
60 to 71. And you have not produced any document that the registration is done.
No. That
Then-
instruction man perhaps.
Then you also don't get the benefit then. Okay. Heard. Mr. P. Bharadwaj, done counsel for the petitioner. Uh, In the second case, which is that Mazida Khatun,
Mazida Khatun is my wife, my lord, and same reference
Okay.
fee.
where is that opinion in that case?
Same opinion, lord. Same opinion. Same opinion.
But
at
which page in
one-
that?
119.
19. The respondents are there, by filing this writ petition under Article 226 of the Constitution of India. The petitioner is assailed. The opinion dated 29/2018, passed by the learned member, so it's on page 19. And in another, the second case, it will be page, or same page 19. Okay. Passed by so-and-so in reference number so-and-so, dated so-and-so. Thereby declaring the petitioner to be a foreigner post 25/3/1971 stream. Next, the learned counsel for the petitioner has submitted that by filing an additional affidavit, or the petitioner is brought on record, the opinion dated 10/1/2025, passed by the same learned tribunal. Common opinion dated, this one passed by the same learned tribunal in case number FT 378 of 2016, tried along with case number FT 379 of 2016. This is page 35, by which the projected brother of the petitioner were declared to be a foreigner post 25, was declared to be a foreigner of 1/1/1996 to 24/3/1971 stream. And they were directed to register their names before the FRRO, Morigaon within 30 days. Next one. Issue notice returnable on 23/7/2021, 25. Extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Next, the prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner is apprehended, he should not be deported out of the country without order of the court. The same order in both the cases. Name of the petitioner were different. Okay.
Oh, bless.
26.
Another issue will arise here in this case.
Lordship.
The reference was from 1166 to 71, but the tribunal declared foreigner of post 25/1971 stream. Therefore, travel beyond reference.
Lordship.
This you'll have to address on the next date.
I think Lordship, earlier occasion, Aziz Mia case will cover Lordship. Aziz Mia or Rukia Begum for Lordship.
You address us on the next date. Just make a note so that you'll remember. Yes.
26.
Yes.
May I please, my lord? In this case, my lord, I have obtained the instruction, telephonic instruction. As per the instruction, my lord, the father of the petitioner has been pushed back to Bangladesh on 27 May 2025.
27 May 25.
Yes, my lord. That was the instruction that I received today,
But from which location?
my lord.
Do you have-
Dhuburi, my
Hmm?
Dhuburi.
Okay. Ms. Bora, then we can do nothing if that is the instructions. We can just wait for some time to allow the authorities to file an affidavit to bring it on record. And apart from that, nothing. Ms. G. Boral and the counsel for the petitioner is present. Next, all the respondents are represented. Next, Mr. B. Dekar and CC has submitted that pursuant to order dated 13/6/2025 and 16/6/2025, he has received telephonic instructions from the concerned authorities in the Border Security Force that the father of the petitioner, namely Idris, IDRISH, Idris Ali, was declared to be a foreigner by the opinion dated 3/8/2016, past, that will be page 10. As this so and so was apprehended by the border police, was handed over to the Border Security Force on, he was handed over when?
But on 27 May 2025, he was handed over to the authority of Bangladesh. My lord.
Okay, was handed over to the Border Security on 26/5/2025, and thereafter on 27/5/2025, the said Idris Ali has been handed over to the to whom?
My lord, to the authority of Bangladesh, my lord. That I
No,
can
it will
say.
be
My lord,
will be
Bangladesh border guards.
Bangladesh
border-
border
Bangladesh border guards.
border
guards.
guards. Okay, to the authorities, the Bangladesh border guards from location at Dhubri. Next, para. Under such circumstances, the court is inclined to direct the concerned authorities of the Border Security Force to bring this information on record by filing an affidavit, which shall be how much time?
My lord, at least 2 weeks time now. Before that, it will not be possible, my lord. But after vacation, my lord, immediately after vacation, that would be better, my lord.
For which the current CC seeks at least 2 weeks time. Most of prayer is allowed. This is the matter on 19/7/2025, or the affidavit shall be filed by them.
Leave.
Next, the learned CEC is permitted to send a downloaded copy of this order to the concerned authorities so as to enable the filing of affidavit. List on will be after that. Okay. We'll take a short break and come back.
Item 27.
Please, Your Lordship. My lord, impugned opinion is page number 49. My lord, 2017 opinion, so delay is there. Lordship, at this stage, kindly call for LCR and notice may issue. I sign.
Yes.
I Hussain,
I,
I Hussain,
Hussein.
Hussain, Hussain.
Learned counsel for the petitioner. Respondents are there. Supplementary query. All the respondents are there. By filing this writ petition under Article 226 of the Constitution of India, page 49, opinion dated 28/4/2017, passed by so and so in case number so and so and reference number so and so. By which the petitioner was declared to be a foreigner post 25/3/1971 stream. By keeping the issue of maintainability open on account of delay and latches, issue notice returnable on 23/7/1991 as so 23/7/2025. Next. Extra copies within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Prayer for bail shall be considered on receipt of records. Next part, list on so and so. Okay.
Understood.
Just a simple, in the meantime, if she is arrested, she not.
No, 2017 opinion. No, they're not giving that question.
Well, first.
28.
Wait, please, your lordship, here, your lordship, the petitioner's father got picked up, your lordship. Thereafter, he came to know that an ex parte order is pending against his father, your lordship. Your lordship, maybe it's not appropriate, your lordship, for the son to challenge the order that is pending against his father. So, your lordship, at least if your lordship may direct your lordship in this case, to allow me to get the wakalatnama signed, your lordship, for my father, your lordship.
Okay.
Then
Where is the opinion?
Opinion, your lordship, will find on page 46, your lordship.
46. Okay. But we'll have to know where your where the
Your lordship, till I filed this petition, I was not aware, but 2 days before, I came to know that he is in Matia Detention Center. But
detention center or holding center?
of Matia Transit Camp, your lordship.
Transit camp. Okay.
Lordship. But your lordship, as learned senior has said, that at any moment, your lordship, they can be transferred to the holding center. So,
Because Lordship, this
Yeah,
opinion
sir.
was never challenged.
We understand that.
Yes, Lordship.
So if he's available in the
Either in the transit or at holding.
holding center, he'll be permitted to meet and take the
Yes,
wakalat.
take the wakalat.
Okay. Heard. Mr. I. Hussain, the counsel for the petitioner. All the respondents are there. Next part. The learned counsel for the petitioner has submitted that on which date?
your lordship, 20. Your lordship, 24/5/2025, page 16.
24/5/2025. For the father of the petitioner. You just say, what is the name of your father?
Your Lordship, Moinul Haq.
Moinul Haq.
Detention, ex parte ordinances which are contested.
Father of the petitioner, namely, Moinul Haq was apprehended by the police personnel and accordingly, on inquiry being made, the petitioner has come to learn that by an ex parte opinion dated 8/11/2023, passed by the learned member of Foreigners Tribunal, Karbi Anglong at Difu, in FT case number 123/2007, was declared to be a foreigner of post 25/3/1971 stream. Next paragraph. It is submitted that as per further inquiry made by the petitioner, he has come to learn that his father is currently lodged in the transit camp Matia Gwalpara, and there is already an ex parte opinion against him. There is every likelihood that he may also be transferred to the holding center at Matia Gwalpara for his deportation. So it is submitted that challenge to the opinion by the petitioner may not be maintainable, and therefore the petitioner is praying for liberty to meet his father at the transit camp, Matia Gwalpara, and or at the holding center at Matia Gwalpara.
Or Kokrajhar also, Lordship.
Huh?
There is one at Kokrajhar also.
He will
Holding
transfer
center.
there also.
Anywhere, Lordship, we have no information. So Lordship can put a slash Matia Gwalpara / Kokrajhar.
Okay, slash. No, Kokrajhar, then there is a different address.
7 Petulant. 7
And or at holding center under 7th AV Battalion at Soraikula, Kokrajhar. So as to meet the petitioner, meet his father, and to take his signature in the Wakalatma to facilitate challenge to this ex parte opinion. Next paragraph. Next paragraph. The Learned Standing Council for the FT matters has opposed the prayer made. Next paragraph. Be that as however, considering the nature of prayer made, the court is inclined to allow the petitioner, namely Alim Uddin, to produce a certified copy of this order before the superintendent, transit camp Matia Gwalpara, and out before the in charge of the holding center. In Matia Gwalpara, it will be superintendent or it will be in charge?
SP border lordship.
No. Holding center would be superintendent. Only superintendent.
Let me clarify, Lord.
Okay. So, we make it in charge, whoever is in charge, holding center, Matia Gwalpara, and obligor before the in charge of the holding center under 7th AP Battalion at Saraikula, Pokrajar, wherever the father of the petitioner may be lodged. And on production of a certified copy of this order, the said authority shall allow the petitioner and one family member to meet the detained person, namely Mohammed MD, Mohammed Mainul, MAINUL, Hawk, HAQE. Against whom against whom opinion dated 8/11/2023 was passed in FT case number 123 of 2007 by the Foreigners Tribunal Defu. Most of the said authority shall also permit the petitioner to obtain his signature in the Wakalatnama, which would be authenticated by the in charge of the holding center, public transit camp. Next para.
Respectfully bold. No?
List on 24, 25, 6, 2025.
Till then, he may not be pushed back, so if pushed back or
If
deported.
he hasn't been pushed back, lordship,
Of next para. In the event the petition, the said the father of the petitioner has not been pushed back, he shall not be deported out of the country without order of the court.
Lordship, apart from filing the, obtaining the signature of the Wakalatnama, I may be allowed to meet and your lordship supplies some.
We have allowed you
Lordship,
to meet you and one member of the family.
Lordship.
If he has already deported, then nothing will.
Yes.
no, my friend is saying if he's already been pushed back, then nothing will happen. So we have no idea, lordship. So
Okay.
let him go and find out, lordship.
Just before, when we said it that he would be allowed to meet, before that you write, comma, if not already pushed back. Okay.
Copy, I mean,
Item 29 for motion.
May please, your lordship. My lord, here in this case, we have challenged the proceeding, my lord. My lord, kindly have a look at, my lord, the investigation report of Form 1, page 23.
Where is the opinion?
My lord, opinion has not been delivered, it's ongoing, my lord. It is, my lord, we have challenged the proceeding, my lord. My lord, here kindly have a look at, my lord, the inquiry report, interrogation report, Form 1, Annexer 2.
You see, quashing is not permissible because the authority will have to give this, foreigners tribunal will have to give an opinion.
My lord,
That is the
my
requirement
lord,
of.
I have challenged the proceeding because there was no investigation at all in prima facie, my lord.
No,
The-
maybe
form-
you are
the-
right.
My
Maybe
lord,
you are right, but still an opinion has to be given. It can't be quashed.
no, we have challenged the proceeding, my lord. Because the challenge proceeding has been taken cognizance, my lord, without any fair investigation. The inquiry report says that I am untraced. And
Mr. Sigdar, whatever be the very good reason, let us say you have a good point, but still reference cannot be quashed.
my lord,
law
my
requires
prayer
that
is
he has
that,
to be brought to a
my
logical
prayer is
conclusion.
that there shall be a fair investigation, giving me all opportunity to produce my documents. That has not been.
Now you can produce in the tribunal.
No, my lord.
tribunal.
No, my lord. I have a defense, my lord, at the investigation stage, my lord. My lord, and where is the materials, my lord? On my approach that the proceeding will be.
We cannot
we are-
become the original authority.
My lord,
To
on what,
examine whether there is.
what
there is
basis, my lord, the reference has been made, my lord, kindly have a look at, my lord.
But we can't.
Lordship may kindly have a look, my lord.
It's a
If-
premature
Mr. Sikdar,
petition,
No, my lord, it
lordship.
is not
We
premature.
can't, you see, we can't examine a document and then say, give our opinion. We can't become the original authority. We are exercising statutory jurisdiction.
My lord.
Once there
My
is
lord.
an order, we can say, we can say.
Therefore, my lord, therefore, my lord, we have challenged the order, my lord, at annexure 9. My lord,
Lordship,
annexure
without
9
the
at
order-
page 45. My lord, on my application that there shall be a fair investigation and fresh investigation, the tribunal has directed to make an inquiry to ascertain the stream. The police, my lord, after interrogation, the report has been submitted at page 44 that there some statement has been taken a fresh, and this, as per the fresh statement, there is no material against me, my lord. How this case may be taken up, my lord? My lord, kindly have a look at, my lord, my lord, the inquiry report at annexure 8. On my application, the court has directed to make a fresh inquiry to ascertain the stream. Then, my lord, some statement has been recorded, and the statement, my lord, at page 48. They have said nothing against me, my lord. Annexure at page 48 and 50. They are saying that since more than 15 years back, they were residing in other place. Thereafter, after shifting, they are residing in my place since 50 years back. So there is no material, my lord, doubting my citizenship. That is the statement of the witness of the border police. Lordship may call for the records, my lord.
Lordship, since this proceeding has started in the tribunal, Lordship, the tribunal ought to pass an opinion, and only after that my friend can approach this court, Lordship.
My lord,
In between,
my lord,
this
I have a
interim
right
order
at the
come
right
in
of
between.
defense at the investigation stage. That is the judgment of the full bench judgment and the Supreme Court judgment in Sarvadna Sonal 2 also. And in the recent, my lord.
Which paragraph?
My lord.
Sarvanand Sonowal.
Sarvadna Sonal, my lord.
I will read out, Lordship.
My lord.
Sarvananda Sonal.
Paragraph 60.
I'm reading out.
I have not.
42.
I have
Let
not.
Mr. Sikdar read that. Let me give it to Mr. Sikdar. Let him read it.
My part I'll read, Lordship, not his part. Paragraph 42 says,
No, first let Mr. Sikdar complete, then we'll hear you.
his paragraph is,
My lord.
Let Mr. Sikdar complete as a petitioner, then we'll hear
yes,
you.
Lordship. Paragraph 60 here, what you want to read?
One net is
It 1 or 2?
it 1.
This is 1, my lord. This is not 2. Yes, my lord. Paragraph 60. Having regard to the fact that the tribunal in the notice to be sent to the proceeding is required to set out the main grounds, evidently the primary onus in relation thereto would be on the state. However, once the tribunal satisfied itself about the existence of grounds, my lord, in the second line is my case, my lord. The proceeding is required to set out the main grounds, evidently the primary onus in relation thereto would be on the state. So, my lord, state has onus, and in full bench judgment, my lord, full bench judgment, there is specific, my lord, the guideline has been paved, how the investigation has to be conducted, my right at the investigation stage, right of defense at the investigation stage. That has been clearly, my lord, cited in the full bench judgment.
Which paragraph?
In paragraph 97, my lord. Full bench judgment 59.
97.
97, my lord. My lord, full bench has observed about the fundamental rights of the person facing the proceeding, my lord. All opportunity should be given to demonstrate that he is not a foreigner by producing his relevant documents at the investigation stage. That is the line, my lord.
Investigation stage before the police.
Yes, before the police.
But
That,
not in
that right
between.
has not been given to me.
But not in between. I'm sure it's not in between. Investigation से भी तो नामों भर के between. Documented media. If what official he say it is reference to 2010. It is the official job. I think 10, 11 or reference. 25 or the
Para 98 also, there is first line, the reference cannot be mechanical. This is something more than mechanical, my lord. Hyper technical. On mere doubt, my lord, without any basis, there shall be no reference, my lord. Some materials have to collect. That is the, my lord, Sarvanda Sundal to para 60.
Para
Para 60, my lord, Sarvanda Sundal para 60. The initial owners of the state to collect materials of doubt. This type of, my lord, allegations, my lord,
Give the
reference,
citation again. It is not opening up. Muslimuddin Mandal, please give the citation.
my lord, Muslim Mandal, paragraph 97 and 98, my
Please give
lord.
the citation. Which in app is not.
2013 1,
Just a moment.
2013 1 GLT page 801, my lord.
2013 4 GLT,
My lord, 1 GLT
1 GLT.
809. Para 97, my lord, first 3-4 lines, my lord, discussed about the fundamental rights. And opportunity should be given at the investigation stage.
Okay. Yes, Ms. Verma.
No, I know the same. Lordship, I'm reading from Sarvananda Sonowal 1, Lordship, paragraph 42. It is elementary that a person who has illegally come from Bangladesh to India and is residing here for his better economic prospects or employment, etc., would never disclose that he has come from Bangladesh and would assert that he is an Indian citizen, national and resides in India. There is no question of his telling his date of entry or giving any information on the aforesaid points. According to Rules 7 and 8 of the rules, the inquiry officer has to submit a report in Form 2 and items 5, 10, 11 and 12 are exactly identical to that in Form 1. Rules 10, 10A and 10B lay down that an application to the tribunal under Section 8(2) shall be made in Form 3. An application to the central government under Section so-and-so shall be made in Form 5. And the declaration under Section 8A(2) shall be made in Form so-and-so. Form 3 requires the applicant to furnish the following information regarding the alleged illegal migrant. Whether he entered India on or after 25/3/1971. B is date of his entry to India. C is whether he is a foreigner. And D is whether he entered India without being in possession of a valid passport or travel document or lawful authority in that behalf. The 43 is the contents of the application has to be affirmed by the applicant that what is stated in the application is true to the best of his information and belief. The application to the central government has to be made in Form 5, which contains a similar column 6 with 2 further additions, namely, the approximate distance between the place of residence of the applicant and the alleged illegal migrant. 2 is since when the alleged illegal migrant is staying at the said place. So, Lordship, the form has all these informations. Whatever information has been given in 2011, this inquiries of 2011, Lordship. It is not a recent inquiry.
My lord, kindly have a look at the
Please
NPC.
let her complete. Let her complete.
So, Lordship,
If you will argue, I
2000
can't listen anything.
2011 inquiry, Lordship. The typed copy, Lordship, the first typed copy says Annexure 1. Information that is 2011-2009. FT case number is of then and memo number is of 8/2/2010. Information has been furnished to me that the person whose name and particulars are furnished below is suspected to be a foreigner. You are hereby ordered to make inquiry under Foreigners Act so and so and submit your findings through the supervising officer. In this regard, please note that while submitting your report, you should invariably verify the nationality record of the person and close relatives and family members. Name and particulars of the foreigner, Lordship. It will, I guess. Name and particulars of the foreigner is their Lordship, and it's signed by the SP. SP has given this letter to the SI to go ahead with the inquiry report, Lordship. Now, Lordship will come to the typed copy of the interrogation report, Lordship. This is of the year 2010.
2011-9.
27/6/10 is been signed by the inquiry officer. His name is Sahajamal Ali, to his age 21 years, address in Bangladesh, Pakistan. He has furnished it, that is why we have written it, Lordship. We will not go ahead and write somebody coming from Borpeta or that is coming from Batinda in Punjab, Lordship. Address in India, he has given his address, place of birth, Bangladesh. Did he, she held any Bangladesh, Pakistan passport? No. Did he, she own any house in India? No. If not, whose land he is staying temporarily at government land? This is the answer given by the proceeding, Lordship. Profession, labor. Did he, she previously used to come to India often, occasionally for employment and then return? No. since when she is continuously staying in India, since for last 5-6 years. Has he or she since moved the authority claiming Indian citizenship? No. Name with address of the other members of the family, parents, wife, children are there, but he is unmarried. What is the plea of the foreign nationals? How did he come to India? Why has he been staying in India, leaving his native place? He entered into India without any valid document. Serial 14. Page 24, Lordship will come to the next page. What is the evidence available in this regard to his nationality? Statement of witness, statement of witnesses enclosed. Documentary evidence nil. Not a single document was produced by him during interrogation, Lordship, or during the inquiry. If he is a voter in India, if so, when did his name appear? No. Name with addresses of the witnesses from whom information in respect of the foreign national is received. So the witnesses' names are there, Lordship. 1, 2. 2 names are there. And then the inquiry officer's report. During inquiry, it is found that suspect Mohammad Sajamal Ali, son of late Taji Ali, untraced from the given address. Untraced means, Lordship, once the information
Just
is
a moment.
Yes,
Mr. Sikdar,
My lord.
while referring to Sarvanand Sonwar paragraph 60, you are referring to Sonwar, Sarvanand Sonwar 1 or Sonwar
Two, my
2?
Two.
To para 60.
Yes, my lord. There is a one line, my lord. Initial onus is on the state to collect materials of doubt.
Okay.
Yes, my lord, my friend has sorted out, my lord, the paragraph 18 of the inquiry report. I am untraced. Then how
No,
this,
just a moment.
how this materials
Let her
have been-
complete. I'm just asking you a question because that is a query. Let her complete.
So this was the report, Lordship, which was forwarded, and then the next is order of the SP forwarded to FT for opinion.
Okay.
So notice was sent to him. He has appeared. He was untraced, but he appeared, Lordship, in the proceedings. Now he is taking a plea that the inquiry report is not correct. The information in the inquiry report is only what he has furnished to the officer. How will we know if he is married, unmarried, if he has parents, brothers, sisters, family? Nothing, Lordship.
I am untraced. That means I was not made by the police. I was not in contact with the police. How, my lord, this report
Lordship,
can
he
be
is
there,
to-
my lord. This materials.
Now,
Hmm.
untraced.
If both of you submit, then I'll be adjourning the matter. I can't listen to both of you together.
My lord, my lord.
One at a time is good enough.
Sorry, my lord.
Lordship, when the final report was given by the inquiry officer, he says the address given by him, he is not to be found in that address. So that is untraced from the given address. He appeared, he gave his information, and when the report was ready to go, he remained untraced. He cannot say that he has not met the police, Lordship. The police has not interrogated him. This is a complete wrong statement on the part of my friend. You cannot twist the words, Lordship. Only after he remained untraced, Lordship, the police could not trace him. Then the SP wrote, forwarded to the FT for opinion.
Okay.
So, Lordship, even in page NHA 8, Lordship will see SP's report is there, the learned the inquiry report in connection.
Call for record will, my lord, discover many things, my lord.
It will
My lord,
discover, but your
many, my
things
lord.
at the
Then we'll take it up on Monday.
correct.
We take it up on Monday.
Yes, Lordship.
Let the matter be listed on Monday as
Right.
both as the counsel for the petition and the Ms. A. Verma runs standing also for the FT matters are both.
My lord, it is from Guwahati, my lord.
Are both
No, not on Monday, Lordship.
are
There
both
is-
simultaneously making submissions. Monday, both of you, if you don't speak, I just can't.
Lordship may call for the records, my lord, at this stage.
No, we'll take it up on Monday. I have requested you, both of you, so many times, not less than 5 times, that both of you may not argue together. But you can't refrain yourself. Both of you stand up together, and therefore I can't understand. Everything gets washed away.
Give him his chance, lordship.
I don't know,
His chance.
but in my head, everything gets washed away. It's a centrifugal force working.
Monday, lordship.
Monday.
My lord, my submission is that, my lord.
Whatever
The
be a good
tribunal
submission,
tried
but
in the-
Mr. Sigdar, I
9 to
requested you
50.
not less than 5 times that please both of you may not argue together. But this is something you did not listen. I won't permit in the courtroom two learned counsel to argue together. It's just not permissible. Not once, we requested you 5 times. Both of you may not argue together. Still it is persisting, we can't help it. I can't hear two of you.
Sorry.
Upgraded item 12 with 13 for orders.
No, there is a office note. A report has been called for by the Honorable Court from the DLS similar. They said that because of non-availability of fund, they could not release the interim compensation. But
They need to place it, otherwise.
I have spoken to the departmental authorities, but some communication I have received that for this year, some amount has been earmarked, and the from Asalsa, the
No, you see, the reason is that on the administrative side, Mr. Nath,
Madam,
on administrative side, for some reason or the other, either from the portfolio district or from somewhere, it comes that the funds with the DLSA is not enough with them. So that is why we said that once the earmarked fund is there, because compensation has to be released.
that's true. But in the meantime, I have also received this instruction that the State Legal Service Authority has been requested to submit the requirement of fund. The fund is.
But this will take
positive.
years.
But
Today, you see, I'll pass an order today.
true, madam.
2 weeks, there is an holiday.
Logic.
It goes after this reopening, it goes to the State Legal Service Authority. Then they make requisition of funds. Your standard reply would be that the supplementary budget
No, budget.
would have been come by July. If it doesn't come, then it goes to September.
But,
Then you say that it will go to December. Supplementary budget, then it goes to March. So it will take a year to get these funds.
Well, Lordship may kindly consider, my lord, this year's 25-26 budgeted amount of 18 crore rupees, the later reflects, my lord, that is already earmarked, my lord, 18 crore rupees for this financial year. And the requirement of the proposal from the SLSA has to go to the department, they will release the amount.
No, but this is, you see,
That letter has already been written to the SLSA.
you see, this is a compensation to be paid by the state.
True, my lord.
So let the state, let the finance department directly make the payment.
Well,
Why you should route it through the legal service authority? This is a case of death in custody.
there is a mechanism to pay the amount of victim compensation.
You'll have to create a way.
That my lord, I'll
Just
take
like
up.
flood waters, what you call rain flood waters make their way.
I'll pick up, my lord.
From one place or the other, the water must go away. If water is held, then there are landslides. So you take a call how it is to be done.
I'll take
But-
up. I'll take up.
But routing of the funds through DLSA, SLSA, and then coming back to the party,
I'll take it up. I'll take it up.
it's a 22 matter. You tell us who are the authorities who are required to be called, we will call them. We give you, since there is a vacation already, we give you time till 15th of July to have a meeting with all the departments with whom you can. and come out with a solution to make payment of this ex gratia of 2 lakh rupees to be paid to the petitioner. If not, the authorities will tell us who are the authorities who are in the helm of the affairs to take a decision, and we'll call them here to have a solution.
Malad, I'll apprise, Malad. The normal mechanism, Malad, we have taken the instruction and in that manner. I'll definitely convey, Malad.
Because unless you tell us, you see, at times we don't understand these budgetary allocations which come by way of a chart. That these are the funds, these are the requirements, these are not. The issue would be that in the concerned district legal services authority, what is the actual claim which they have already raised, and how much funds are given to them? It can't be that you see that, for example, let us say that they have been given 100 rupees, and now there's a requirement to pay 200 rupees. The difficulty is that this DLSAs give payment by virtue of court orders. So this secretary, who is our judicial officer, he or she is always in a risk of contempt being issued against him or her. The reason is that if we are asking 2 lakh rupees to be paid, and if the DLSA concerned says that I am out of the funds, I can only spare 10,000 rupees. Now, please tell me, you shift your place from here to Mr. Mahmood's place, and then say whether you will like it.
No,
Once you stand there, you will not like it.
no.
So if there's a 2 lakh rupees requirement, there has to be 2 lakh clear money with it.
True.
It can't make pro rata payment.
Correct.
So that is the difficulty these
Well-
officers face.
Malad.
And there are so many letters which we get from the portfolio districts,
Lordship.
where the DLSA express their inability to make payments.
Malad, in many cases, Malad, Lordship, seen.
Mr. Mahmood?
Yeah.
Till 15th, we have to wait for some time. Mr. M.U. Mahmood, then counsel for the petitioner, is present. Next para. This court by an order dated 9/5/2025 was inclined to award interim compensation to the extent of rupees 2 lakh to the two petitioners in this writ petition. First off, it was provided that the said compensation shall be released by the District Legal Services Authority, Borpeta, as and when the funds are placed in this regard by the Home and Political Department, Government of Assam, or any other concerned authority. Next para. By order dated 9/6/2025, this court had directed the registry to call for the report from the member secretary from a DLSA Borpeta to inform the court as to whether the interim compensation has been paid or not, and as to whether the funds have been placed by the Home and Political Department from a Government of Assam or any other concerned authority. Next para. Next for the Secretary, District Legal Services Authority, Borpeta, by a letter dated 6/6/2025, amongst others, has informed the court that the petitioners did not appear before the said authority to submit the bank account details and other particulars. Moreover, it has been stated that no funds are presently available with the District Legal Services Authority, Barpeta, for disbursement of compensation to victims under the Victim Compensation Scheme.
Now, my lord, details of bank accounts have been provided.
It is also, the court is also informed that previously a sum of rupees 34 lakh and subsequently a sum of rupees 66 lakh was placed before the District Legal Services Authority, Barpeta, and the said funds were fully expended, EXP and DED, expended by March 2025 through payment of compensation to victims. Moreover, the District Legal Services Authority, Barpeta, is in requirement of a sum of rupees 82 lakh for disbursement of compensation to victims under the Victim Compensation Scheme. Next para. The learned senior comment advocate has produced a copy of communication dated 23/4/2025 from the Deputy Secretary to the Government of Assam, Home and Political Department, addressed to the Member Secretary, Assam State Legal Services Authority, next for the
By this letter, they have requested to submit the financial proposal, financial sanction proposal, but they have not received any response to that, as informed to me.
the said the text of the said letter is quoted below. Next paragraph. From the above quoted letter dated 23/4/2025, it appears that there is no likelihood of an early payment of compensation as per order dated 9/5/2025. In this case, the son of the petitioner number 1, who was the younger brother of the petitioner number 2, had died by hanging while he was incarcerated in District Jail, Barpeta.
Hanging, we have objection.
Then we decided, then we withdraw this compensation amount. If you have, because this is a part of the order, he died by hanging. Whether it is homicidal or non-homicidal, we never decide that. Did we decide it was a homicidal suicide? Or it was a, what you call, homicidal death or suicidal death. We are not saying that. But can you change the situation by saying that he did not die by hanging? What is the, kindly tell me the word which I can use?
Insuspicious.
No, tell me, when you have objected, please, you have objected to the detention. Please tell me what word you have used.
My thinking is that may be taken in defense plea by them. So
You see, this objection you raised when we were dictating last time also. You are repeating this today also. If we start thinking about the ripple effect our orders would make, then we will not be able to pass a single order in a day. We can't have an analysis of the order before we pass an order. That means we'll have to frame the entire order in the mind, then analyze it, then say what our orders will carry a meaning. We take responsibility for the order which we are passing, and we are trying to enforce it. We are not giving a fact finding. In a criminal petition, is the High Court authorized under 226 to pass a fact finding, to record a fact finding? No. It has to be examined by the authority to whom we send the matter to for investigation, or to the district judge if we think so, fit to have an inquiry made by the district judge. You're not making a and you see, you have disturbed the dictation without caring to read the order dated 9/5/2025. You have a copy of 9/5/25?
I've gone through it.
Would you remember it now? Then please tell us what paragraph 3 was.
Right.
No.
Only I haven't.
Because you don't take responsibility of your own statement. And you expect that the court will be so scrupulous that it will not make a mistake. In paragraph 3 of the order, we have stated like this. Please hear it now. It is submitted that while the jail administration claims that it was a case of suicide, but the same is disputed by the petitioner by projecting that a color of suicide is being portrayed, whereas we will kill in custody. Is a specific statement we have made in the order. Every time we don't have to repeat it.
No.
Next one, accordingly, as a in view of the said situation, comma, we hereby direct the Home and Political Department, comma, Government of Assam, to have a joint meeting with the Finance Department, comma, Government of Assam, so as to find out a way that this that the compensation amount of rupees 2 lakh as ordered by order dated 9/5/2025 be expeditiously provided to the District Legal Services Authority, Borpeta, and for onward payment to the petitioners. Stop. Alternatively, we also provide that in the event the state government has any other mechanism to make direct payment of the compensation amount to the petitioners, comma, they would be free to do so without routing the money, compensation amount through the District Legal Services Authority, comma, Borpeta. Next paragraph, we expect that the said authorities will take a decision within 15/7/2025. Next paragraph, the learned senior government advocate shall transmit a downloaded copy of this order to the concerned authorities of the Home and Political Department, Government of Assam, so as to enable them to have a meeting with the finance department of the government of Assam to work out modalities of early payment of the compensation to the petitioners in terms of order dated 9/5/2025. So we have given both. If you don't want to look it through this process, you can do it directly.
Lot.
List on, which we have given it 15, 21/7/2021.
Well, already we have provided our detailed bank accounts.
Okay.
So can I take a little lever? Item number 15, it says tender matter stay order is operating below. We have filed an appeal. We filed an application for the, it will be taken up on either tomorrow or Monday, Miller. I leave it to Rod.
Today is Wednesday, Friday we can take it up.
Friday I'm not sure, madam. I'm on the other side. Madam, next Monday or Tuesday, madam.
Let it, if it is not on Monday, Miller. But Tuesday also I have no problem. 24th. No, take it.
This,
I think Monday, Millard. Millard.
no, can we make it Wednesday then? Any inconvenience?
Wednesday, I will not be there, Millard. If it is not inconvenient, let it be on Tuesday, Millard.
Okay, let it be Tuesday then. Okay. Item number
15, Millard.
15.
Yes.
Okay, both sides, you say, both sides are represented by their respective learned senior counsel, along with their instructing counsel on record. Next, positive time, the matter cannot be taken up today. Next, list on, make it Tuesday. Tuesday would be 24/6/2025.
Deep level.
But item 17 may pay for listing on Friday.
We will not be able to take it up until we give that, what you call, we complete our this, what you call, APSA matters. We are not in a position to hear. Mind is too crowded with many things. You have to excuse us for these 2 days. After that, make a mention.
My matter may be taken up Monday, Miller. 11 item, expert order,
We are not,
Monday.
not on Monday. Make it Wednesday, we'll see.
What is the obvious?
I have a prayer for item number 19, Miller. Here, can, after vacation also, Miller.
After
Let it be quick,
Court master will give you a date. These days we are not.
I understand.
Just unable to.
I understand. That's why I'm not paying for vacation.
Despite our effort, we will not.
Yes, I understand that. Obliged.
We are sprinting against time.
Yes.
There's some difficulty this time.
True.
Okay. Okay. These matters they will accommodate one matter. Rest we'll see.